Well, as you know, that trial turned out to be a lengthy trial. There were 3 attorneys, Ellis Arnold, Arthur Saldiver, and myself, in relation to 3 persons who were accused of that matter, who had been in prison for some time. The trial proceeded. It was under the amendment to the law. It was a trial without jury, and at the close of the prosecution case, which revolved essentially around one particular witness who claimed to have heard statements. He's not an eyewitness, he didn't see anything. It was a case that would have been based on circumstantial evidence. That witness was allowed to testify. There was no objection against him testifying. And he said that he was at a yard when a vehicle left with the deceased, with the person who was later deceased, and then he was also at the yard when the vehicle returned and that person was not in it. At the close of the prosecution case, the law allows that where the attorneys are of the view that there was not sufficient evidence for the court to continue the trial, they have a duty to the court, they have a duty to their clients, to the accused persons, to make a submission. A submission was duly made, pointing out that in the trial itself, in the presentation of evidence, there was insufficient evidence, not enough evidence to continue with the trial. And lengthy submissions were made, and of course the prosecution also made lengthy and extensive responses to those submissions. At the end of hearing and doing his own research into the matter, the trial judge made a ruling that under the law it would not be of any further assistance for the trial to proceed, that there was in fact insufficient evidence. Now there is an important point. The D.P.P's office has appealed. This is their prerogative. They have appealed, saying no, the trial should have gone on. There's going to be some kind of hopefully new ruling that may emerge out of that matter, because as the law stands, as most of the law stands, when a judge is in charge of a trial, it is the jury who are the judges of the facts. Where there is a trial, this new business of having a trial without a jury, the judge then becomes the jury. He is also going to decide on the facts of the case, and he will decide on the law governing all the relevant facts. In this case, there is no jury. If in the course of the trial proceeding, the judge, who is now also the jury, is saying, but where is the evidence? Where is any link between what this person is alleged to have done? Where is the evidence? And if he's seeing no evidence, if there are no facts, if there was a jury, he would be required to leave the trial to proceed. When the prosecution closed their case, it would then be for the defense to present the accused persons to say anything if they wish to, and to say it either from the dock or from the witness stand, or to remain silent, which is also their right, and to call any evidence, any witness that they wish to present to the court.